right, we'll now move on. The phone lines are ringing off the hook. We have Vikas Bhatia who's just dialed in. Hi Vikas, how can we help you?
Hey, hi. Good evening to both of you.
Good evening.
Thank
Tell
you
us your
for taking
question.
my call. A very quick query. I mean, it's a complicated case, but nevertheless, wanted to keep it very short and brief. Basically, I have a residential plot, provisional allotment since 2013 with a large developer in Gurgaon. I would not like to name right now. And more than 3 years have elapsed. So I wanted to exit out of the provisional allotment and seek my refund. So I found this interesting clause in the buyer's agreement.
Okay. What is that clause?
Which talks about 36 months of commitment period, after which they can take recourse to 6 months grace period for unforeseen delays and plus extra delay of 12 months, etc., etc. But my key question here is, what is the definition of requisite approval which they are referring to, because it is not defined anywhere in the buyer's agreement. However, because it is not defined, I am taking recourse from my own personal interpretation standpoint that the license which they got in 2009 to develop and sell the plot should be the logical reference point for calculating 3 years and the extra period which is mentioned in that clause. Am I right in doing that? That's the question number one. Question number two, I have had some email correspondence with the developer, and they have defined 3 requisite approvals because I asked the question under the current real estate bill, and they talked about this license, environment clearance, and NOC, and they are taking the 3 years start period from the environment clearance, which is from December 2013. So I told them that, look, I took the allotment from you in January 2013, and at that time, whatever approvals I asked you for, you told me you had everything in your hands. But looks like you never had the environment clearance for next 10, 11 months. So therefore, isn't that also a misrepresentation of fact? So that's the question number 2. 3,
Vikas, I'd request you. I'm sorry to interrupt you, but let's go step by step. Let's go with your first question
because you are more analytical, though you are not a lawyer, but sometimes these analysis to a non-lawyer puts into the confusion while interpreting the clauses of agreement.
So let's start with this first question, Uday.
Let us come down to your basic questions. I find that your agreement has a lot of unfair clauses. In a simple English, we call it that they are opposed to the public policy, and therefore they are unconscionable in legal terms. So the normal agreements, which are standard agreements under various acts that builder does, there has to be crystal clear, and DLF was put nearly 300 crores fine for unfair agreements. Lot of judgments of the National Commission. Your solution is to go to a consumer court, ask for either possession within a stipulated time limit or compensation for not giving the possession, or alternatively you can even claim market value. You are talking of refund with interest, I am talking of market value. The project is certainly delayed by no standards, by an common sense also. Once you are doing a booking in 13 months, average reasonable period for construction is 2 years. There are several provisions in several acts, but even rationally National Commission or the concerned consumer court can decide on this, and 2 years is maximum. You don't have to work out whether it is from commencement certificate or whether it is from environment. It can't be from environment. Normally it is from commencement certificate of the project, or IOD, in certain places known as IOD, information of disaffiliation. So you have to go through these 2 documents, IOD or commencement certificate, and take the date as a base.
But quickly tell us, Uday, in a case where the agreement reads prerequisite approval, just tell us in brief, what does that mean?
See, this does not mean anything, for the simple reason, prerequisite approvals is a job of the builder to take. He is a professional. He should know. Once he takes 100% money, especially from consumer point of view, in a Consumer Protection Act, technically one can really interpret and analyze in civil court. But if you go before a consumer court, there is something called equity, and consumer courts are on preponderance of probabilities on the situation in our country. Especially they are supposed to be an inquisitorial judiciary and not an adversary judiciary. So this is a very general term. What do you mean by prerequisite? You have to really define in an agreement which authority. There are about 30-40 permissions the builder has to take. He has to be aware. If he takes so much money, nearly 100%, then it is his duty to give within a stipulated time limit, which is reasonably 2 years.
All right. I hope that answers your question, Vikas. You basically need to go through your agreement properly. You're probably analyzing it a bit too much, but probably get it checked from your lawyer, and you will exactly understand what is mentioned and how you can go about with recovering.
Suesha, one important point for consumers here and for our client also.
Yes.
I mean, for the person who's asking this question,
yes,
is we even for taking doing something, entering an house, we call a priest and we see auspicious occasion. Before buying a flat, why don't you consult a lawyer? You put your hard-earned money here.
Of course, that is something that goes for everyone. Please consult your lawyer. Get all your documents checked by a lawyer before you decide to sign on that agreement.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.